It often happens that there's an unfair dismissal case brought against an employer in circumstances where the employer is making the position redundant and makes an offer of alternative employment to the employee, and the employee refuses the alternative, is for whatever reason not prepared to take the alternative job that's offered. The employee then will essentially be terminated and will probably bring a claim for either unfair dismissal or a claim that they are entitled to redundancy, that they have not disentitled themselves from a redundancy payment by reason of their failure to take up the alternative employment, and they'll be saying that their decision to refuse the alternative was reasonable in all the circumstances. There's a number of cases, as you might imagine, dealing with this very topic, but there was one recently in November of 2021 involving a creche manager who refused alternative employment that was offered to her. She brought a claim then for a redundancy payment against the employer. The employer's position was that she wasn't entitled to redundancy because a reasonable alternative had been offered, and therefore she was disentitled from it. The Workplace Relations Commission dealt with the case and found, amongst other things, that the proposed move to the position of Montessori teacher, entailing the loss of her manager's position and answering to an additional two persons in positions of authority above the complainant, reveals a level of responsibility below that of her previous role. I find that it does constitute a demotion. Therefore, it was reasonable for the employee to refuse this offer. So this employee was the manager of a creche. She had been offered a position as a Montessori teacher. It involved the loss of her manager's position and answering to two additional persons in positions of authority above her. She refused. The Workplace Relations Commission adjudicator found that that was a reasonable refusal. The employer also made another offer of a role where there was no demotion, but it was a verbal offer and would have led to additional travelling and childcare costs on account of its location. That raises the interesting question: is the employee entitled to refuse an alternative by reason of issues or factors personal to them outside of the workplace? For example, childcare obligations, or travelling across the city, or travelling to a different location, or whatever. In this case, the adjudication officer found that there would be an additional commute of 40 minutes per day if using a car, and a longer commute if travelling by bus. The distance between Nutgrove and Beaumont is 7 kilometres in excess of the distance between Nutgrove and Barrow Street. The Labour Court concluded that the same journey and associated travel meant that a job offer was not one that constituted suitable alternative employment. The Labour Court, in a previous case involving Mr. Garrett Brown, in a case called Mr. Garrett Brown, said that in assessing the suitability, and this is vitally important, in assessing the suitability of an offer and the reasonableness or otherwise of refusal to accept an offer, they're guided by a decision, an English EAT decision. The suitability of employment is an objective matter, whereas the reasonableness of the employee's refusal depends on factors personal to him or her and is a subjective matter to be considered from the employee's point of view. I'll say that again because it's very, very important, and it's the takeaway that you need to take from this video. The suitability of employment is an objective matter. The employer can put forward anything, whereas the reasonableness of the employee's refusal to take that job will depend on factors personal to him or her and is a subjective matter to be considered from the employee's perspective. So in this case, the adjudication officer held that the refusal of an offer of a manager's position in the Beaumont facility due to the factors personal to her was a reasonable refusal and decided the employee was entitled to a redundancy payment. This is an important case from the point of view of these types of cases where there is a redundancy, but the employer is saying you're not entitled to redundancy, you're disentitled because I'm making you a reasonable alternative. And the fact then, or the circumstances, may arise where the employee refuses the offer, and the question arises then, were they reasonable in refusing the offer? So we see here in this case that the suitability is an objective matter, whereas the reasonableness of the employee's refusal depends on factors personal to him or her and is a subjective matter to be considered from the employee's point of view. I hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.